The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning, Council, and thank you for cooperating and allowing us to pivot to the Zoom arguments today in light of the inclement weather. I will ask Mr. Doug Shima to please call the first case on the 11 o'clock docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Wednesday, February 2nd, 2022 consists of two cases. First case to be heard is case number 123410, State of Kansas versus Tanner Scott Mora, Sedgwick County, briefs both sides. Immediately following, the second case will be appeal number 116541 in the matter of Scott M. McFall, matter and attorney discipline. Your Honor, the appellant in State v. Mora, 123410, has reserved 3 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Council, would you please state your appearances?
Michelle Davis, appearing on behalf of the appellant, Tanner Mora, ready for argument.
May it please the court, Assistant District Attorney Matt Maloney for the state, present and ready for argument.
Thank you, Council. Ms. Davis, you may begin your argument.
Thank you, Your Honor. In this case, the state charged Mr. Mora with alternative counts of felony murder, that a killing was done in the commission of an armed robbery, or that a killing was done in the commission of distributing marijuana. The district court entered 2 convictions against Mr. Mora, but only sentenced him for 1, which would be a life prison sentence. The state's evidence in this case was that it was a parking lot in a winter evening at a Wichita Health Club, and the shooting took place in a car. The deceased, a gentleman by the name of Wade, was found in the parking lot with a bag of marijuana. The detective looked at Wade's phone and determined that Wade was a distributor of marijuana, a drug dealer, based on the content on the phone. The detective also tracked the phone number that was used to set up the meeting in the parking lot and associated that with an email address belonging or associated with Mr. Mora. So apparently some sort of app on the phone that was tied to his email address that was tied to that phone number. The state's evidence in this case at trial was primarily the testimony of a woman by the name of Kornman, and she worked at a Burger King, and acquaintances of hers, a gentleman by the name of Bledsoe and Mr. Mora, borrowed her car. She testified Mr. Wade was staying with her at the time. I'm sorry, Mr. Mora was staying with her at the time, and she said that in a later period of time, Mr. Mora told her, and I want to get this right, she testified that Mr. Mora told her that he and Bledsoe went to buy some weed. The unknown to Mr. Mora, Bledsoe intended to demand that the guy give them the weed, free weed. When the man refused, Bledsoe shot the guy. And the physical evidence supports that. The physical evidence was that basically Wade was in the back seat of the car and shot in the back, apparently, as he's getting out of the car, and then he's found laying in the parking lot. So that was the state's evidence, and it's our contention that the state's, neither of the felony murder convictions stand on sufficiency of the evidence. The state doesn't have to charge the underlying felony. The state doesn't have to convict a defendant of the underlying felony for felony murder. And the state didn't do that in this case. The state only charged felony murder, but the state does have to prove the felony murder. The state has to prove that the killing was done while the defendant was committing or attempting to commit a certain felony. And then the jury's given the elements of the felony, in this case, the elements of attempt, and the jury has to find all of those. It's our contention on the first felony, the distribution of marijuana, that the facts of the state did prove the evidence supported only an attempt to possess marijuana, which is a misdemeanor. And in order to have felony murder, you got to have a felony. So the state in this case, charged distribution of marijuana. In this court's case law, clearly establishes, there's Crosby and then the Hillard case, that in order to support a distribution conviction, there has to be evidence that you possess the controlled substance, and then you attempt to transfer the controlled substance to another. In the Hillard case, this court said that a buyer simply trying to acquire or acquiring a substance by itself is insufficient to find guilty of distribution. The way the state obtained the conviction in this case is that the prosecutor told the jury that distribution covered both the seller and the buyer. And defense counsel argued to the jury that Mr. Mora was not a distributor of marijuana, that he was simply trying to obtain and possess marijuana. So you've got counsel here arguing sort of competing theories to the jury. But it's our contention that this conviction is based on an erroneous application of law, which is the prosecutor telling the jury the distribution applies to the buyer and the seller. If there aren't any quick questions on that issue, I'll go ahead and move on to the other felony murder then. The other felony murder we believe is invalid, which is the armed robbery or attempted armed robbery, because the evidence does not establish that Mr. Mora had the intent to commit an armed robbery here. There's no evidence that Mr. Mora planned a robbery, that he knew that Bledsoe had a gun, or that he participated in actual robbery. And in addition,
Counsel,
Yeah, go ahead, Justice Siegel. Go ahead.
okay, sorry. There is evidence that he intended to participate in a drug buy, correct?
we went to do a weed deal. That's
Yeah.
what Kornman said, is that she summarized to the detective that the detective said that Kornman told him that Mr. Mora told her we went to do a weed deal. That would be the evidence there.
And based on the pick instruction on aiding and abetting liability,
Mhm.
couldn't the jury have found the defendant guilty of the aggravated robbery based on a foreseeability theory?
No.
And why not?
Okay, two different, I'm going to try and get there, but one, that instruction was inappropriate in this case. In a felony murder case, you don't give that instruction.
Well,
And-
I understand the argument, and we have case law that says that it shouldn't be given if the quote unquote other crime is the felony murder. But it's not
Right.
clear to me that that's the case here. In other words, that the instruction that was given, which my understanding is it was the straight pick instruction, actually could have been referring to the intended crime being the drug buy and the quote other crime being the aggravated robbery.
That's correct. And
And why? What would be the problem with that?
because these are the, in order to aid and abet someone to commit a crime, you have to aid and abet with the intent. And this, the jury instruction says that you have to have the show that Mr. Mora had the intent to commit the crime. In order to convict somebody of an attempted robbery, you have to find that the defendant committed an overt act with the intent to commit the crime. With that requiring of intent, those are conflicting theories. You can't.
Well, doesn't pick 52.14, which is responsibility for crimes of another,
Mhm.
intended and not intended. I mean, it uses the concept of foreseeability to extend aiding and abetting liability.
That's
and so,
correct.
yes, there is a culpable mental state requirement, but when the culpable mental state is intentional, in other words, let's just take this out of the realm of this case. Hypothetically, an individual intends to participate in a drug buy, and then an ag robbery happens. And if that ag robbery is foreseeable, doesn't aiding and abetting liability extend to the aggravated robbery?
No, based on Overstreet. The Overstreet line of cases that say when the crime requires an intent, you can't rely on a theory of foreseeability. In other words, foreseeability is a legal theory of aiding and abetting, but really it's one it's unnecessary, it's statutory, but it's really been codified in felony murder already. So,
I want to ignore felony murder for a minute. Just pretend there was no felony murder. And we do have case law that says if the quote unquote other crime is a specific intent crime, then you can't use force foreseeability. But I'm not sure that's the case here.
you do, because they have to show an intent. You have to show an intent. That's the problem. For either an aiding and abetting or an attempt theory, you have to show the defendant intended. So if you're going to go with foreseeability, those are completely, there's something wrong here. I don't think that's that, and that's what Overstreet says, is you can't use that theory of liability when the state is required to show. The state said they would show that he intended to commit this crime. You then can't support a conviction on a foreseeability theory. Those two legal, that's what Overstreet says. Those two legal theories are directly conflicting. And in fact, if you look at the aiding and abetting PIC instruction, it says that the person who is aiding and abetting has to have the mental culpability of the principal, the mental culpability required to commit the crime. That's what Overstreet says. In order to aid and abet somebody, the principal, you've got to have the same mental culpability. So what you're saying is if you apply paragraph 2, the principal, the state has to show an intent to commit a robbery, but you're saying you can convict somebody of aiding and abetting off foreseeability. So therefore, you're convicting the aider and abetter on a lower degree of proof than you are.
You're just saying that your argument is, which might be correct, that PIC instruction is just wrong as a matter of law.
Yes, that's what Overstreet tells us. With certain crimes where the state has to prove an intent, you can't give that instruction. It's an anomaly in the law. And in fact, the instruction doesn't make any sense. And the jury was confused. The jury asked the court specifically this. The jury said, how do we apply paragraph 2? When it says a person could reasonably foresee the other crime, does that mean that Mr. Mora could reasonably foresee the other crime, or is that a reasonable person? And that is a very good question. You don't see this sub-paragraph. There's not much law on this, because it's really just not applied. Like I said, it's usually really actually codified in the felony murder. So you can see the jury struggling with this. But the instruction itself is contradictory, because it's saying you've got to show the aider and abetter had the same mental culpability, intentionally aids the other person to commit the crime. You can't intentionally aid somebody to commit a crime unless you have the intent for the crime to be committed.
Well, what about, isn't there an underlying factor, at least there's a proposition that they enter a drug deal not intending to pay for the drugs. Is that right?
The evidence doesn't support that Mr. Mora was part of that. Mr. Mora told Poorman he didn't know that Bledsoe was going to try to get the weed for free. He didn't know that. There's no evidence there. In fact, the district court upheld this conviction on the basis that this is what the court cited. Bledsoe had a gun. No evidence that Mr. Mora knew that. And a lot of people carry guns. Mr. Mora's phone number was used to arrange the meeting at the parking lot. The fact that the phone was used to arrange a meeting at the parking lot to buy drugs does not establish an intent to aid a robbery. And the court said Mr. Mora was at the scene. And that's why the jury is asking about paragraph 3, which says that association with the principal and presence at the scene are insufficient to support aiding and abetting conviction. And the last thing the judge cited was that Mr. Mora didn't have a job. Well, that's not sufficient evidence beyond a reasonable doubt to show an intent to commit a robbery. And the only way I can figure that the jury got to its verdict was based on this legally inappropriate jury instruction that apparently the jury tried to follow. And on that basis of that instruction, this is an invalid conviction, because the state was not required to present proof beyond a reasonable doubt of Mr. Mora's intent to participate in a robbery. And I'm out of time, Chief Justice.
Are there any other questions? Okay, thank you, Ms. Davis. Mr. Maloney?
Thank you, Your Honor. May it please the court. I'll also confine my remarks to issues 3 and 4 unless the court has any questions on the first issue. Of course, this court's well aware of the standard of review on a sufficiency of the evidence challenge, and that calls for this court to look at the evidence in the light most favorable to the state and determine whether a rational jury could have found the defendant guilty beyond a reasonable doubt. beginning with issue 3, which is the felony murder conviction based on the underlying felony of distribution of marijuana. Counsel in the brief relies on Crosby, and Crosby does stand for the proposition that in order to sustain a conviction for distribution, there has to be evidence that the defendant actually possessed the drugs. But Crosby can be readily distinguished on the facts because that was a case in which Crosby was charged with distribution as a completed crime. And so in that case, absent evidence that Crosby actually did ever gain possession of the drugs, the conviction was overturned because of insufficient evidence. Here, by contrast, the defendant was not charged with distribution of marijuana, but rather it was alleged as the underlying felony. And of course, a felony murder conviction can be sustained if the defendant was committing or attempting to commit the underlying felony. So in this case, we have a situation where even if the defendant, like Crosby, can show that he never actually did obtain possession of the marijuana, and admittedly, the marijuana was found in a baggie that was still next to the victim at the crime scene. But unlike in Crosby, that does not give the defendant relief in this case because, again, a conviction was possible if the evidence showed that he was if he was attempting to commit the underlying.
What was the evidence that the defendant here intended to distribute the marijuana as opposed to just buy it for personal possession?
Right, and that's where Hillard comes into place. A later case indicating that the mere acquisition of the controlled substance isn't sufficient to find a guilt on possession. And here what we have is a case where Bledsoe and the defendant and Bledsoe were working together, went there together to participate in this drug deal. The text messages from the phone that the defendant himself used indicated that we were in the parking lot. And when you look at that evidence, that would indicate clearly that the defendant had knowledge that this drug deal was taking place. And the use of we and the fact that these two gentlemen were acting in concert would indicate that the plan all along was for defendant and Bledsoe to split the proceeds or just to split the marijuana. And so when you look.
So I don't understand how any of that demonstrates that the defendant intended to in turn sell the marijuana that he got.
I don't think that the definition of distribute requires sale. It includes any transfer between.
You're saying that the anytime two people go to buy drugs together, that just because they split the drugs, that's the distribution?
I think that under the definition, the statutory definition of distribution, that would be enough because it does contemplate a transfer between two individuals.
Where's the transfer? If I'm a buyer and my buddy's a buyer and we buy together, we just bought. I mean, if my buddy and I go to the grocery store to get some Pepsi and we each buy a 20-ounce bottle of Pepsi, and then we drink the Pepsi. How is that? I guess I'm struggling with your theory of distribution.
No, I appreciate the question. And I think the distinction there would be that you and your friend would each be individually buying a bottle or a can or a 6-pack of Pepsi. It would be your own transaction. Here, I think the circumstantial evidence is that this transaction was that there was a baggie of marijuana that the victim was going to sell, in his mind, thinking it was a sale, was going to sell to these two individuals, and that then the two defendants, would have been responsible themselves for divvying up the drugs amongst themselves. It wasn't a situation, to my knowledge, where there were separate baggies that they were going to be buying, and Bledsoe would purchase one baggie and the defendant would purchase the other. I think that the circumstantial evidence here is that they were going there to purchase one baggie of marijuana, that baggie was found still near the victim at the crime scene, but then the two defendants would have had to transfer the
Is that how
proceeds of that.
is that how the distribution was argued in this case? Or was it just argued that, hey, distribution covers the buyer?
I think counsel is correct on that. I'd have to review the transcript, but I would note that to the extent that that was what the prosecutor or argued, of course, this case was decided before Crosby came down. But regardless of the prosecutor's theory, the question ultimately for this court is whether under the Crosby test, there was sufficient evidence to support the conviction, even if that might not have been the angle that the prosecutor argued, consistent with the case law that existed at the time. Again, the defendant certainly has an argument to make that he and Bledsoe were not going to divvy this up. And that's certainly an argument that he could have made to the jury. And if the jury would have believed that, then we as the state would not have had any recourse. We wouldn't be able to appeal that. That would have been the jury's, they were entitled to do that. But now on appeal, where the evidence must be viewed in the light most favorable to the state, and where we can look at both direct and circumstantial evidence, the fact that the defendant and Bledsoe were together, that they both clearly knew that they were going there to participate in a drug deal, the fact that the defendant was the one whose phone was who was communicating with the seller via the text messages, all of those indicate that the defendant had knowledge that this was a drug transaction. And I think when you look at the use of the word we, it indicates that both of these people were going to be sharing in the proceeds. And I would, it's in the record, a picture of the baggie that was found on the victim's or near the victim's foot. And I would argue that, again, from a circumstantial evidence standpoint, that baggie contained more drugs, more marijuana than what you would typically expect for one person to be using by himself. And so I think
that's the amount. Do you recall the amount?
I don't believe that it was I don't believe it was in the record, and I don't know that it was actually weighed. If the record shows that I'm wrong,
you can't rely on that then if it's not in the record.
I couldn't rely on saying it was a specific weight, but I can certainly rely on this court being able to look at that baggie. The picture of the baggie with the drugs is in the record. And I think certainly that's, again, from a circumstantial standpoint, this court could evaluate whether that does appear to be the amount of drugs that one person would be using for himself, as opposed to something that these two defendants plan to share. Turning to issue 4, which is the felony murder with the aggravated robbery is the underlying felony. First, I want to point out that while counsel highlights the fact that, in her opinion, there is no evidence whatsoever that the defendant knew that this was going to be a robbery. And she cites Kornman's testimony that the defendant said to her that he did not know that this was going to be a robbery. And while that is a correct recitation of Kornman's testimony, I would note that in her interview with police, Kornman did not say that the defendant was unaware that this was going to be a robbery. She simply said that they went there to do this weed deal, and that when the victim didn't turn over the drugs, he got shot. And so in that statement to police, she in no way tried to distance the defendant from personal knowledge that this was going to be a robbery. And I think that, again, looking at circumstantial evidence, including the fact that there was all sorts of testimony about the fact that the defendant had very little money. This was a person that had to basically go to Burger King to be able to use Wi-Fi, to be able to get some food from Kornman when she was working there. He was using a phone that he had been given to him that was a government, I believe, some sort of a government assistance phone. When you combined all of the evidence indicating the lack of any real money for the defendant, and also Bledsoe, I might add, I think that that would indicate that what these two gentlemen did was that they went there intending to get these drugs by any means necessary, up to and including robbing the victim. And
Mr.
so-
Maloney, I just want to circle back. Did you say it was during her interview, Kornman's interview, or at the preliminary hearing? What did you?
Yes, I think it was in one of her statements to police. It was in one of her interviews where she indicated that she told Detective Shoemaker that the victim was shot because he wouldn't give up the free weed.
And so
again,
was that was that statement introduced at trial?
yes, that was in the record. Yes.
Okay. Thank you.
And so again, while she didn't, admittedly, I'm not arguing that she told Detective Shoemaker specifically that the defendant fired the shots or that he was the one who specifically took the lead on the aggravated robbery. She certainly did not say what she did at trial, which is when she for the first time added the testimony that the defendant said that he had no idea, that he thought they were just going there to purchase weed. So when you have a situation like this, where you have two people that are acting in concert, they both went there knowing that this was going to be a drug deal. And when you look at the fact that they were together and that Kornman in her statement did not indicate that the defendant had disavowed any knowledge of a planned robbery, I think that circumstantially, that is evidence that the jury could view as showing that the defendant knew that this was going to happen. And again,
counsel, let me ask you, do you have to have, part of your argument that I'm hearing and have read that bothers me is this notion that poor people wouldn't have the money to buy the drugs, so it must be robbery. Okay. I mean, the problem is he was not arrested on the scene. So you don't know what cash he would have had in his pocket. And it bothers me that really your argument is, well, he's poor, so he couldn't have cash in his pocket.
and I do appreciate.
If you take the cash, if you take this is a poor defendant argument away from this, do you have enough evidence for ag robbery?
I think we do, based on Kornman's statement that the defendant, that the victim was shot because he wouldn't give up the free weed. The evidence that the defendant and Bledsoe were very much working together that night, that the text messages were sent from Bledsoe's phone. And I want to be clear, I'm not suggesting that no poor person would ever have the ability to buy drugs. Certainly, I think we all know that that's not true. But on the facts of this specific case, when there's so much evidence that he really didn't even have enough money to afford food or the basics, that he was living rent-free with Kornman, that he was going to the Burger King, and that she would sometimes try to make sure that he got some food while he was there. I think that when you're now at the appellate level and you're looking at the light most favorable to the state, I'm simply using that circumstantial evidence as an added layer of evidence in addition to what I would consider to be even stronger evidence based on Kornman's statement to Detective Shoemaker, combined with the fact that these two, that the defendant and Bledsoe were very much working in concert. I think that there is, viewed in the light most favorable to the state, this court should find that that is sufficient evidence, notwithstanding the fact that the defendant is claiming that he had no idea that this robbery was going to happen. So it's a combination of all of those factors that I would suggest supports the theory that there was sufficient evidence of the underlying aggravated robbery.
And counsel, I'm sorry, your argument on Kornman's statement is based on what she didn't say, right? It's not actually any of her testimony. It's what wasn't included in that initial statement. like an affirmative statement that separated the defendant from the co-defendant.
Correct. Yes, she did not say that specifically that the defendant knew that the robbery was going to happen. I don't think I think your representation is the most accurate way to put it, that she didn't really separate out the two defendants during that statement. It was more along the lines of they went there to get drugs, and when the victim didn't give them free weed, he was shot. So yeah, she didn't distinguish between the two. And I would argue that when you're talking about a case like this, especially when these two were working together and that there was the aiding and abetting aspect of things, I think that again that would be sufficient. And just like the previous issue, the jury certainly would have been free to accept the defendant's interpretation and say, we don't think that there's anything linking him personally to knowledge that a robbery was going to happen. And had they decided that, then we would have had to live with the results. But because they looked at the evidence and found otherwise, and we're now looking at that in the light most favorable to the state, our position is that the evidence was strong enough to overcome the sufficiency of the evidence claim by the defendant.
Counsel, there's a precision problem here. You just said she said that the victim wouldn't give up the free weed, and the word free wasn't in that statement, right? Did I write that down wrong?
Let me review real quickly, Your Honor, that portion of my brief and see exactly what the statement was.
I wrote down give it up,
I think I have at the top of page 25 of my brief, starting actually at the bottom of 24, Detective Shoemaker testified that what Corman said was that the defendant told her that he and Bledsoe, quote, went to do a weed deal and the guy would not give it up. And then when asked to clarify what that meant, Corman explained that the victim, quote, wouldn't give them free weed.
Okay.
So yeah, and that's on in volume 12 at page 90, Your Honor.
Okay, thank you.
Let me follow up, Mr. Maloney. And assume for purposes of my question that we don't agree with you that there's any evidence that the defendant intended to commit this robbery. Can the defendant, in the state's view, still be legally liable for the aggravated robbery under the aiding and abetting theory that was instructed using PIC 52.14? And I'm looking specifically at the middle paragraph of instruction number 7, which says that a person's responsible for a crime committed by another is also responsible for any other crime, et cetera, if that person could reasonably foresee the other crime as a probable consequence of the intended crime.
It's certainly an interesting question. And my recollection of Overstreet is that...
Well, I'll just interrupt you there and say Overstreet is a premeditation case in which the court said, when you have a specific intent crime as the quote other crime, then foreseeability, you can't use the theory of foreseeability. But here, arguably at least, this is a general intent crime, ag robbery, not a specific intent crime.
And that was where I was going with that, is that, yeah, that was my recollection of Overstreet, was that it is limited to specific intent crimes. And I don't know that as a result, I don't know that aggravated robbery applies. It's defined as knowingly taking property from the person or presence of another, etc. Doesn't seem to include a specific intent. And so simply based off of Overstreet, I don't know that the argument that defense counsel is making is correct. But I would ultimately note that given the unique facts of this case and the way that it was charged, I think that ultimately this court wouldn't necessarily need to even reach that issue, because that question would be premised upon saying, well, if there was evidence that he was participating in the distribution, but not
I want you to assume that you lose on that question and that you lose on the other primary argument you made, which is that there's evidence that he intended to do this ag robbery.
Well, and I think that's my point.
If you lose on those questions, can the state, is there still sufficient evidence based on this aiding and abetting liability theory?
I think there would be then in that situation, because if there's evidence that he was, so again, to make sure I understand, your premise would be that we hadn't specifically even proven that the defendant intended to, I think where I'm getting confused is because in my mind, if the defendant, if we prove the distribution, then.
I want you to assume that we don't agree with you on that. You
Okay.
lose that issue.
So under that theory, then it would just be.
Let's just create a hypothetical really simply. Two guys go to do a drug buy. One guy has the intent to commit an ag robbery and the other guy has no clue. It's just a clueless guy who wanted to buy some drugs.
Well, and that's where I think my point is. And in that scenario, we have proven that he went there to do the drug buy. And because that was charged in a separate count, if we've proven that he went there knowing that the drug buy was going to happen, then we've already proven count one. And so that's why
does aiding and abetting liability extend to the aggravated robbery? That's what I'm trying to ask.
I think it would. I think if you're strictly looking under Overstreet, it would. I think obviously this court is
okay,
obviously.
So let me just ask my final follow-up then. If that's the case, in this instance, your opposing counsel is correct, as I read the record, which is that the jury was very confused about this instruction. And in fact, it is confusing because the way both the state and the defense argued this instruction to the jury, they argued that the quote, other crime was the felony murder. And that just can't be right. And so given that confusion, even if this is a proper jury instruction, what do we do with the fact that the jury was confused and the parties argued it incorrectly?
I don't know that the parties necessarily argued it incorrectly. I think that the parties did. You're correct, Your Honor, in that the parties did very much look at the other crime as being the murder.
But that can't be right. That can't be right. The only way this instruction makes any sense is if the other crime is the aggravated robbery.
Well, my understanding is that the parties would agree, not to go outside the record here, but I think the state's position is that based on Gonzalez, we recognized in hindsight that that second paragraph would not have been or shouldn't have been included. So
why shouldn't it have been included if the other crime being referenced is ag robbery? This is where I just have obviously this is where I'm stuck on this case.
Well, I think that's where the parties didn't contemplate that. I think that that instruction was given and it included all three paragraphs. I don't think the parties fully thought through the issue, because I do think my understanding is that they did envision, and I think that's consistent with the way that the state argued the case to the jury, is that we were looking at the other crime as being the murder, and then with respect to both of the charges, the intended crime was, in the first count, it was the distribution, and in the second count, it would have been the aggravated robbery. And so I think that's why the parties, that was the way that the parties viewed the evidence. And I just don't think that there was thought put into the question that you're asking, which is that, well, perhaps this paragraph actually could have been appropriate if argued that way. So I think that when you do look at the way that the case was argued, and when you look at the instructions as a whole, as I cite in my brief at the top of page 29, the instruction setting forth the elements of count one made clear that the aggravated robbery was the intended crime rather than the other crime. So I would agree that there was some confusion, but as with the previous issue, ultimately this court's task is to look at what the law is and then determine whether there was sufficient evidence to support each of the two convictions. And of course, because they were charged alternatively, if you find that there was sufficient evidence of either of the underlying felonies, then the defendant's conviction for felony murder should be sustained. I know I'm well past my time, so unless there are questions, I would conclude my argument by asking that this court affirm the defendant's conviction.
I see no other questions. Thank you, Mr. Maloney.
Thank you, Your
Ms.
Honor.
Davis, you're reserved 3 minutes.
Yeah, on the Kornman statement to the detective, the context of that was that Mr. Mora was scared and was reporting to her that he had seen a guy get killed. And if you look at volume 12, page 108, the detective says, when she says the guy would not give it up, the guy would not give free weed, Kornman, the detective didn't ascertain from Kornman in her statement who was doing what and who was responsible for what. So the detective says it's not that Kornman's being inconsistent. This is just the detective reporting what he got talking to Kornman. And Kornman was clear, though, that Mr. Moore said Bledsoe shot the victim. And then on the attempt, in this case, the state's theory was in the attempt to possess marijuana, an attempted robbery was committed, leading to a death. If you look at the attempt statute, it says the state has to prove an overt act with the intent to commit the offense. That makes attempt a specific intent crime. And I'll cite the case on that is MEHLING. It's at 34 Canap 2nd, 122. Both of these crimes under an attempt theory require the specific intent. Overstreet applies. You cannot convict based on a foreseeability theory. The state has to prove the intent, not that the crime was foreseeable. In addition, you would then be saying that the state has to show intent with the principal, but doesn't have to show intent with an aider and abetter. And under any sort of theory of due process or equal protection, that makes no sense whatsoever. So it's our contention there's insufficient evidence to support both of these convictions. If you disagree, the evidence is incredibly weak on the robbery, but if you disagree, I think this court also has the option to say that based on the erroneous jury instruction on foreseeability, a new trial is warranted. I think that avenue is also open to this court. But it's definitely our position that the state just didn't prove their case. And the argument that the prosecutor made to you today is basically the same argument that the prosecutor made to the jury in the same basis that the district court relied on to uphold these convictions. And it was always they're doing this, they're doing that, they're together. And our case law is clear that simply association with the principal, the fact that you're with somebody who commits a crime doesn't make you also liable. And that's exactly the basis the state's used for these convictions. And that concludes my time.
Are there any questions? Thank you, Ms. Davis, and thank you also, Mr. Maloney, for your arguments today. The court will take this matter under advisement. The court is now in recess until 9 a.m. Oh, no, I'm sorry. We're going to have a pause as we bring in people for our next case. So we'll say goodbye to Ms. Davis and Mr. Maloney, and hello to Ms. Walker and Mr. McFall for the second case.
Your Honor, the second case for the morning docket of 11 a.m. is appeal number 116541 in the matter of Scott M. McFall matter and attorney discipline. The Office of Disciplinary Administrator has reserved 3 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Would you each please state your appearance?
Alice Walker, Deputy Disciplinary Administrator for the Office of the Disciplinary Administrator Petitioner, present and ready for argument.
Scott McFall, Respondent Pro Se, present and ready for argument.
Thank you. Ms. Walker, you may begin.
Madam Chief Justice, and may it please the court, this is an original proceeding in attorney discipline involving Scott McFall, who's been licensed to practice law in the state of Kansas since 2008. The original misconduct in this case actually occurred in 2011 when Mr. McFall did not file an appeal on behalf of a criminal defense client and didn't properly communicate with that client. For that misconduct, he was placed on diversion with our office in April of 2014, and he stipulated that his conduct violated KRPC 1.3 diligence and 1.4 communication. Part of his diversion required that he provide our office with a copy of his continuing legal education transcript within a certain amount of time. He did not do so, and so the diversion was extended through October of 2015. Unfortunately, in that time, our office received additional complaints against Mr. McFall, 2 from criminal defense clients that were not originally docketed, but Mr. McFall did not respond to requests from our office, so they were docketed and investigated, and Mr. McFall did not cooperate with that investigation. In addition, in October of 2015, Mr. McFall was administratively suspended for not complying with attorney registration requirements. He then appeared in court on several matters in Johnson County. That judge later saw a roster of attorneys that had been suspended and saw Mr. McFall's name. The judge reached out to Mr. McFall and let him know that he had engaged in the unauthorized practice of law. Mr. McFall took immediate steps to remedy his suspension. He actually hand-delivered documents to the Judicial Center and was reinstated on, I think it was October 28th of 2015. He also self-reported to the Office of the Disciplinary Administrator this misconduct. But again, when that was investigated, he did not cooperate in that investigation. The diversion was ultimately revoked, and all of these matters were set for formal hearing in July of 2016. At this time, Mr. McFall did cooperate with the Office of the Disciplinary Administrator. He did file an answer in which he admitted his misconduct. He also outlined some significant personal matters and trauma that had been occurring in his life and substantial mitigating factors. He also entered into a joint stipulation with the Office of the Disciplinary Administrator about the facts that I just recited, and that was presented to the hearing panel in July of 2016. Following that hearing, the hearing panel issued a final hearing report where they found that Mr. McFall violated not only 1.3 and 1.4 as outlined in that original diversion, but also KRPC 5.5 for the unauthorized practice of law, 8.1 for not responding to the Office of the Disciplinary Administrator, 8.4D indicating that his conduct was prejudicial to the administration of justice, 8.4G that it indicated that he was unfit to practice law, and it also found that he violated Kansas Rule of Professional Conduct. At the time it was 207, it's now 210, the duty to cooperate. Reviewing that, but coupling it with the substantial mitigating factors present in Mr. McFall's case, the recommendation at that time was for a 90-day suspension with a requirement of a reinstatement hearing. Now, this is where this case becomes unusual and deviates from the standard attorney discipline case that we see before this court. The case was originally docketed for oral argument in early 2017. But prior to that oral argument, Mr. McFall recognized the toll that the trauma and personal matters had taken on his life and his practice, as well as his mental health, and he sought disabled status. Our office did not oppose that request, and this court placed Mr. McFall on disabled status. I believe it was January 19th of 2017. In that order, Mr. McFall was required to obtain an evaluation approved through a KLAP provider within 60 days. No evaluation was provided to this court. Neither party updated this court about the status of the case. And in February of 2021, this court issued an order to both parties to file a status report. Our office did that on March 15th of 2019. And in that report, Mr. Hazlitt noted that he had talked with Mr. McFall that same date and learned that he had not filed or had not completed that evaluation as ordered by this court. So then these both parties appeared before this court in May of 2021. And at that time, they basically made a joint recommendation to the court to remove Mr. McFall from disabled status and transfer him to a temporary suspension. That would give the ability to remand the case back down to the hearing panel for further findings regarding the failure to comply with this court's January 2017 order. That is what this court did, and the case was remanded back down to the hearing panel for further proceedings. A supplemental formal hearing was had in August of 2021 in which Mr. McFall cooperated and appeared. He testified that back in January of 2017, not only was he dealing with personal struggles and some mental health as a result of that, but he had also turned to the abuse of alcohol. He recognized that and he took it upon himself to enter into a 30-day treatment facility. He successfully completed that treatment. And upon release, he simply did not read this court's order transferring him to disabled status. And so he negligently did not realize he had the requirement to obtain that evaluation. Looking at all of the misconduct that occurred in this case, but recognizing the mitigating factors, as well as the fact that Mr. McFall had been removed from the practice of law, either through the disabled status or through a temporary suspension since January of 2017. At the time of the formal hearing in August of 2021, the Office of the Disciplinary Administrator requested a 6-month suspension rather than the normal or original 90-day request with the requirement of a reinstatement hearing. In its final hearing report this fall, the hearing panel made that same recommendation, and that is my recommendation to this court today, that 6-month suspension be imposed against Mr. McFall with the requirement of a reinstatement hearing. We believe that that adequately addresses the misconduct in this case, not only the original misconduct, but the subsequent misconduct of failing to comply with this court's order, but also recognizes the substantial mitigating factors in this case. Thank you. I'll stand for questions.
Ms. Walker, the only question I have is that we did order an evaluation in 2017, but he subsequently went to treatment at Valley Hope in the meantime. At least in my mind, doesn't that mitigate the need for an evaluation? The fact that he did do a subsequent treatment program, and I assume there's some reports available from that. Or were they not submitted, or what happened with that treatment plan that he initiated at Valley Hope?
Justice Rosen, I agree that I think it mitigates because it addressed at least part of what was going on with Mr. McFall back in January of 2017 or leading up to January of 2017. That the order did require him to get an evaluation through a provider approved by the Kansas Lawyer Assistance Program. He did testify about that, although I'm not sure from the record that he actually provided any of those official documents to our office. But in our investigation leading up to the hearing in August of 2021, there was not a concern that he did not actually do that treatment and follow up. There was also discussion in the testimony in August of 2021 about the treatment that he had continued with and recommendations that it may be important for him to get back into AA to help support his sobriety.
There's a condition on your 6-month suspension, and then he applies for reinstatement that he received some sort of an evaluation. Is that correct?
That's correct. That
prior to the petition being filed.
That's correct. That was the recommendation of the hearing panel, and that can address whether there is any need for any further treatment or whether, as the hearing panel indicated, he could even provide that prior documentation to the Kansas Lawyer Assistance Program and ask if there is any further treatment that's needed at the time he seeks reinstatement.
Any other questions? Thank you, Ms. Walker. Mr. McFall? You remain muted, Mr. McFall.
Can everyone hear me?
Yes, we can. Thank you.
This goes back in time quite a ways. The root of why we're here and how we got here is back in 2011. That June, I had a couple experiences that have impacted me greatly since then. One involved my business partner, and there's some allegations there. And then a week later, my middle child passed away unexpectedly. That kind of threw a wrench into the works. In the subsequent weeks and months, with support from the local bar, which were fantastic, I wound down that practice and opened up my own. Later on that year, I was given a murder appeal appointed to me, and I was not ready for that, but I did not say out loud that I was not prepared or ready to move forward on that. Outside of that, everything started moving forward again. And then 2013, I was surprised by a divorce. We had a second child who was 8 months old at the time. After the divorce, I began drinking more and more, was dealing with depression, and was just in complete denial. I didn't accept the fact that I wasn't handling it properly, nor that I was drinking too much. Fast forward to the end of 2015 and through 2016, and I was not functioning as an attorney should. I was underperforming. I was putting the reputation of the bar at risk, and it was blind sheer luck that we didn't have the dire consequences with one of my clients that could have happened, especially with that appeal not being perfected. Moving through that year was sort of a blur. Early 2017, Judge Moriarty pulled me aside in Johnson County and had a frank discussion with me and wanted to walk through what I was going through and what was happening. And we talked about my alcohol consumption at that point, and I was ready to go and make a change. So with KLAP's help and Judge Moriarty's recommendation, I was able to get the Valley of Hope for 30 days. Since then, I've been sober, just past the 5-year mark. It's amazing when you don't consume a depressant, how depression subsides over time. After the first 6 months, I noticed a major difference. After a year, it was more so. Now, it's scary looking back at what I was thinking and experiencing without reaching out for help and what I thought was normal. Also, while I was in treatment at Valley Hope, I got very lucky with the counselor I had. I never would have given it a chance, but she did some ECG treatments on me. One of the things that was an overriding problem. Is I was basically experiencing the same thing over and over and over again, daily, nightly. It was a memory from when my my middle child passed away. Not to get too many details, but TV has it wrong when you perform CPR, where there is sound that comes out once the lungs are expelled, and air coming out makes noise. And that was constantly with me until I did a treatment that, frankly, had she told me what we're doing ahead of time, I would have said wouldn't work and would probably have been bullheaded about it. But since then, when I walked out of Valley Hope, I had all the weight in the world off my shoulders. Didn't experience that daily constant issue with that memory. That next 6 months, though, instead of focusing on the order here or getting back to practice law, I had to find employment quickly, and I had to start making money. Got a 50-50 plan with 2 children with my ex. And my ex and her husband have been very supportive through this entire time. I began working, did odds and end jobs, then started a full-time job that June. I've turned that into a career. I work at a new company doing work within there, and the company's fantastic. I'm enjoying it. It's really growing, and the culture there is great. And so I never came back to Stan's office to discuss reinstating my license at that time, as I was starting to work in a different field, was working through sobriety for the first time really since I was 18. And moving forward on that, when Mr. Haslett reached out to me when this order came out this year, we had some long discussions on this, and I'm in full support of the recommendations of the 6-month suspension on this. I know the reinstatement, it's been a bit since I practiced law. I'm a little rusty right now. It's been over 5 years, so there'll be quite a bit of continuing education I'll need to get caught up on, and need to get an evaluation or something that shows that. I think it would behoove everyone if I had a follow-up to show where we're at now and presented that to everyone on that reinstatement hearing. And every allegation that was brought forward by the disciplinary authority is true. I don't deny any of that. And during that period, especially in 2016, I reflected poorly on the bar. I made willful decisions that not seek help and that not admit to myself what I was doing. I was willfully ignorant of the position I was putting myself in and those that depended on me and the people in my profession. I'd ask that we follow the disciplinary authority's recommendation of the 6-month suspension with the requirements of the reinstatement, some form of an evaluation showing current status, AA meetings during that time and through the suspension process, and anything else that this court deems necessary. And with that, I'll open myself up for questions.
Any questions? Thank you for your frankness and openness, Mr. McFall, and your argument. Ms. Walker?
Chief Justice, unless there are any questions, I don't have any rebuttal at this time.
Okay. With that, then, we will end today's proceedings and take this matter under advisement as well. And we are truly at the end of today's docket. I tried to get us there prematurely earlier. But with that, the court will be in recess until 9 a.m.